So, ladies and gentlemen, welcome to our discussion on data protection and generative AI, current obligations and upcoming AI regulation initiatives. As the moderator, I'm thrilled to have you here. Today, we'll explore the evolving landscape of data protection regulations in light of generative AI. Our esteemed panelists will provide insights into compliance, ethical considerations, and global perspective on AI governance. Let's dive into this critical conversation aiming to strike a balance between AI innovation and safeguarding privacy rights. Thank you for joining us. Let's begin. And that was a ChatGPT response to the prompt, write an opening remark to the panel about data protection and generative AI. I know everybody already listened to an opening like this, and that's not an innovative way to start talking about generative AI. But I think that's interesting to understand, like, what are the differences between regular artificial intelligence and this kind of new artificial intelligence that is generative AI. Today we have a panel of specialists and brilliant people that are going to help me understand what is upcoming on regulation and what is already being done on this field. So I would like to present them, beginning with Luca Belli, that I don't think he needs further introduction, but Luca is a professor at FGV Direito Rio, where he coordinates the Center for Technology and Society at FGV and CyberBRICS project. He has authored several publications on internet regulation and digital policies and is the director of CPDP Latam. He holds a PhD degree from Université Panthéon-Assas, Paris 2. Dora Kaufman is a professor at the Technologies of Intelligence and Digital Design program at PUC São Paulo, with a PhD in digital media from ECA USP, with a PhD fellowship from Université Paris-Sorbonne 4th. She has 2 postdoctoral degrees at UFRJ and at Teach PUC São Paulo. We already have here with us José Renato, that is online. He co-founded the Laboratory of Public Policy and Internet Latam, and is a member of the Brazilian Central Committee on Data Governance and Brazilian AI Strategy. He is the German Chancellor Fellow Alumnus and holds a master's degree from University of Brasília. Franco Jandana Gena is a policy analyst at Access Now and a lawyer based in Argentina with international experience in IT and IP law. He has also been an active member of the internet governance ecosystem for many years and has previously worked at Fundación Via Libre as policy analyst. And Paula Guedes is a PhD candidate in law at the Portuguese Catholic University with a master's degree in international and European law from the same institution. She's a researcher in law and technology at the Núcleo Legalité at PUC Rio de Janeiro, and a researcher in AI regulation at Data Privacy Brazil Research Association. I would like to thank Franco because he proposed this panel together with CEDIS. So Access Now and CEDIS are organizing this discussion on this very special theme. And I also would like to thank Luca here on behalf of FGV and CPDP Latam for providing us with such interesting conversations and dialogue about all the teams that were proposed through this CPDP Latam year. To talk about AI, generative AI, and data protection, I think it's very difficult, especially today where we have a lot of maybe sensationalist news on what is going on, what is going to change with generative AI. We have a lot of what jobs are going to be lost, what are the lawyers, the future of law. We have some very coachy articles about how can you use it to improve your workplace, how can you use it to improve your research. But when we come to legal grounds, when we come to the regulatory perspective, I think that's important to take off all the noise. And that's what we are going to do here. We are going to try to understand with all these brilliant specialists what are the main differences between regular, if we can call it regular artificial intelligence, and this kind of new, I don't know if we can call it new generative AI improvement that we had over, I think, the past year. So to begin with our conversation, I would like to call Luca Belli and ask him, how does generative AI differ from other technologies, and what reasons can explain this quick rise in the use and development of generative AI as ChatGPT and other softwares?
Thank you very much for organizing this session, and thank you very much for this question. Actually, I think the very best way to explain something is always to start with an example. And so I want to contextualize a little bit to give you an idea of why I became interested with ChatGPT. We had a conference, an event in February, the EU-Brazil conference on AI regulation and governance. And the night before that event, I was already a ChatGPT user, and so I was playing a little bit with ChatGPT, and I started to ask ChatGPT, tell me whatever you know about Mario Costeja Gonzalez, that data protection lawyers know is the Spaniard at the origin of the right to be forgotten case, the Google Spain case. And ChatGPT started to give me a very detailed description of who he was, the kind of debt he had, the insolvency that generated then the case, and then that he was the one at the origin of the right to be forgotten. And so I asked ChatGPT, but how do you know all these things? And ChatGPT replied me, well, this is an artificial intelligence based on information publicly available. And so I further inquired and asked, but all these are personal information. Are you allowed to process personal information? And ChatGPT started to deny that those were personal information, saying, no, these are public information available online. So I started to question again. Then I realized that I was arguing with the chatbot, and it was the first time in my life that I thought, well, that is not healthy. Let's stop it. But then I started to think, well, this is really something that I have to think more thoroughly about. Fast forward 4 weeks where I was doing my life, and I open my computer and I see the Italian authority blocks ChatGPT. I was like, this is very curious because as many of you know, I'm double national. I was born and raised in Italy, but I am also Brazilian. So I was like, if the Italians are already doing something about this, it means that I'm not the only paranoid person here. There is something really to be investigated. And so I started to ask ChatGPT again, tell me everything you know about Luca Belli. And he gave me a very detailed description of some of that correspond to some of my personal information and a lot of other information that are very close to my life, but slightly incorrect or obviously incorrect. So if you know me very well, you know that that is not really correct. If you don't know me, that really sounds correct. Why? Because the goal of the generative artificial intelligence is to provide something that really looks like reality. Like the semantic, they have to be semantically correct, not factually correct, right? Like the famous stochastic parrot, as Emily Bender and Tim Gabriel say. So they parrot things. They look like they are correct, but they are not necessarily factually right. And so I kept on asking questions like, where does Luca Belli live? And actually, I don't know how to call it. It replied me saying, Luca Belli lives in Sao Paulo, which is actually good because now that I will tell you that I petitioned the ANPD, I know that if anyone then is mad at me because I'm petitioning the ANPD because they don't respect the data protection law, they will look for me in Sao Paulo, and so I'm relatively safe thanks to ChatGPT. But taking a step backward. So at that point, when I saw all those personal information and incorrect information, I started to check the OpenAI privacy policy that at the time was pretty much non-existent, very, very basic, like with something like, we process some of your data, and if you live in UK and Europe, you might have some rights. I checked who was the data controller, no indication. So I used the only channel I had to communicate with them via email, saying, first, who is your data protection, who is data controller, and who is the DPO? Second, obviously, you are producing this information to those questions based on the analysis of some of my data. So I would like to have access to the data that you use to train your models. I would like to know where you got those data, why do you process them, for which purpose, and how long you will process them. That are all rights I have according to LGPD, Articles 9, 18, 19. And then I thought that is an excellent occasion to have specified some of the tricky part of Article 20 of LGPD that give me the right to have clear and adequate, the adequate is always tricky, adequate information about the criteria and the processes that are used to produce solely automated processing of data that affect my interests. Because obviously, if anyone in the world asks ChatGPT who I am, and ChatGPT gives a lot of my personal data and a lot of misleading information, I'm directly affected. So I have, according to Article 20 LGPD, a right to know what are the criteria and procedure they use to produce this misinformation that is spread around the world about me, right? I send the email, I receive an automatic reply. I send the email in Portuguese because I'm entitled, according to the data protection law in Portuguese, in Brazil, to write in Portuguese. And I receive an automatic reply in English saying, thank you for your query. We will reply as soon as possible. A week after, no reply. So I sent a further email saying, could you give me a deadline for your reply? No reply until after they implement the first elements that the Italian Data Protection Authority Garante asked them to implement. They send me an email saying, we have implemented this new privacy feature and you can now download your data, which was obviously not a reply to my queries. So that day, I decided to petition the Data Protection Authority and ask them to check whether they are complying or not. My opinion is they are absolutely disregarding and disrespecting Brazilian data protection law, as most of other law around the globe, because there are 62 countries around the world with data protection law. Almost them are very similar in many aspects, including transparency, which is the core issue here, in my view. And so I requested the ANPD to analyze this case. They've received my petition, but there is, as you may know, in Brazil, there is no deadline for replying. So at some point, they will reply to me. But here, this case, I think, brings me to these two considerations I want to share with you. First, most of the startups, not the big tech, actually big tech, they have a compliance department that tell them, if you do this, you will be sued. So don't do this in this way. But most of startups, they are simply ignoring data protection law in their development of generative AI. And this is evident. Why it is evident? From these past months, I've seen that, for instance, they have now indicated who is the data controller in their website, and they have a privacy policy, not a good one, but some kind of privacy policy, which that did not exist some months ago. Why? Because they are starting considering the existence of data protection law now, after 6 years of operation. And the other striking point is that actually they have an enormous market incentive to do so. Because actually we can now meter very well what is the market incentive to ignore totally data protection law and what is the punishment if you ignore it. If you totally ignore data protection law to be the first one to share your service, you gain 10 billion from Microsoft. If the ANPD sanctions you after Luca Belli petitioned them, you maximum have 10 million US dollar, because the maximum, the cap in Brazil for a financial sanction is 50 million reais. At the current exchange rate is 10 million. So there is an order of magnitude of 1,000. So the sanction is 0.1% of the reward the market gives you if you ignore data protection, and you are the first one sharing in the market totally irresponsibly Because I mean, I have nothing against generative AI. I'm all in favor. But my key point is that if we had ChatGPT not at the beginning of 2023 publicly available, but beginning of 2024 or 2025, because data protection law was embedded, as should be according to law, in the technical and organizational practice of OpenAI, nobody's life would have changed. Nobody's life would have changed if you could not do this prompt, this introduction automatically generated, not now, but in 2020. So society would not have been harmed if we had waited 1 year or two to have the service developed according to the law. But they would not have gained 10 billions from Microsoft or from any other funder. So that is the key problem for me. There is an enormous market incentive to ignore the law, and the law does not have sufficient force to discourage this. And so I think it is necessary to have, as in Europe are doing, and also as the Iberican network is promoting, coordination amongst authorities to sanction or to provide some more creative remedies as it exists, for instance, in competition law, which is not necessarily we will sanction you, but you really have to demonstrate us that you are according to this, and this. The FTC, paradoxically, in the US, where there is no general data protection law, is requesting a lot of information about how OpenAI processes information that will be very useful to understand which kind of compliance, if any, they have ever thought about. So those were my initial provocations for the debate, and I pass you the mic again.
Thank you, Luca. And that was really, really interesting because we could see, I think, the development life of generative AI. I did all these tests also, and I was thinking, like, am I exaggerating when I think that maybe that's too much and that's a bit unknown? There is a lack of transparency, and I think data can help us understanding what are the real risks. Because I think sometimes we can be stuck in this discourse that it's dangerous and we need to mitigate and we need to regulate, but without understanding what are the real risks around data protection and its relation to AI, generative AI, because not all the concerns about generative AI are related to data protection, but I think there are a lot of important ones that are related to data protection. So Dora, please, if you can help me understand that, the floor is yours, please.
Thank you very much. I'm afraid that I want to help you to understand, because everything that you have been talking about is in the beginning. There are a lot of things that is not clear. It's a change. I will make some comments, but I'm sure that I won't solve your doubts. Well, the organizer that you proposed to two questions to me, but first I make the opening comments. Regulating AI is not like regulate a product or services. It's not trivial to pre-identify and isolate risk and their consequence. That's the first statement that for me it's very important, because it's very difficult to isolate risk and their consequence. The effectiveness of the law depends on the convergence of the guidelines shared globally, the self-regulation, yes, from the company, for the organization, a regulatory framework, of course, from the public sector. So this is the combination of the three, the guidelines shared globally, self-regulation, and regulatory framework, is very important. It's the precondition to have effectiveness law. Regulation is a collective project that includes regulators, stakeholders, the private sector, academy, and civil society. One point that I participate really now in the beginning of July in the AI for Good that was in the UN Geneva. one of the things that practically most of the speakers talked about or say that one of the problems is the lack of knowledge about the AI by regulators. That's being considered around the world a strong barrier in regulation and subsequent enforcement. Now, how you can regulate something that you don't understand the object that you have to regulate. This is a problem. It's not only in Brazil, but as I have a lot of contacts there in this, I was a fellow in the German university. We had a lot of contacts, and apparently it's a problem in all the world. In Europe, they have also this problem, the lack of knowledge of regulators. Understanding how AI system supply chain work and how to assign different responsibilities take time and qualification. Among experts, there is a consensus that the effectiveness of any AI regulation depends on established standard, like ISO. Well, in Brazil, the bill to create the European framework of artificial intelligence that probably all of you knows, that's a PL 2338, is a good start point. I think it's compared with the other PL, I think this is the quality is totally different. I think, in fact, it's a good starting point, but it requires improvement in general. I separate two main points. First, it's important to reduce compliance costs that negatively affect the innovation and positively market concentration. In my view, medium, small, and startup companies will not be able to meet legal requirements in this PL. And second, it's very important to specify the affected users' rights, avoid the fraud of Wall Street that worried me. It's essential to standardize the evaluation criteria to classify the risk, the content of the evaluation documents, the parameters to be used by the authorities to reclassify and evaluate the algorithmic impact. Risk categorization is inappropriate for evaluating large language model or foundation models, which have unpredictable applications and raises concerns about data protection and copyright. Foundation models are an essential building block that is used by many AI providers to develop their specific AI system. Since the AI Act and the PL 2338 have a risk-based approach and focus on specific high-risk use cases, the law is conceptually not designed to cover foundation models, basically for two reasons. First, foundation models are placed on the market without adapting them to a specific intended purpose, but can later be deployed in a plurality of contexts or may be integrated in a plurality of other AI systems. And second, it's not able to place foundation models in a fixed and permanent risk category as they can, based on new input data, learning new capabilities. The test approved in 14 June by the European Parliament contains two changes to the first draft to adapt to the proposal of the law to foundation models. They introduced an additional assessment stage that the AI system to be classified as high risk must also pose what's called a significant risk, require evaluation of the risk severity, intensity, likelihood, duration, and potential targets, whether an individual, multiple people, or a specific group. And second, a fundamental rights impact assessment, develop a risk mitigation plan in coordination with the National Supervisory Authority and relevant stakeholders before market entry. These changes are welcome. I agree with them, but it remains unclear what methods will be used to these evaluations. However, foundation models, as everybody knows, are becoming so powerful and will occupy such a dominant role in the AI ecosystem that we need a special regime, no doubts about that. No, specific about the two questions that you proposed to me, but first is, what are main risks for personal data protection in the development of generative AI? I think it's the consensus between all of us that the two risks, the privacy, data security, handling of personal data, and the second is intellectual property, harms, copyright infringement, using training data, generating content based on user prompt. But responsibility for harms of generative AI should be applied across the spectrum of actors, app developers, users, others. And the challenge is how to define individual contribution, or how to identify individual responsibility in all the process. This is another difficult question, difficult to change or challenge or difficult to propose, but in my view, IP and data rights must be reconsidered for the age of AI. I think two concepts, individual property and data rights, are obsolete in this environment, this new environment, and you have to rethink about that. How to do that? I have no idea, because I'm not a lawyer, I'm not a specialist in data rights and IP, but I think you have to reconsider, rethink about that. The second question that you proposed was, what safeguards can be used to reconcile technological development and respect for principles such as transparency? Well, transparency is key in a regulation proposal, no doubts, but full accountability won't happen in a black box technique. That's for sure. In this, now practically all the use of AI now, practically all of them are basically in this technique, deep learning technique. And if you consider using this technique, we want to happen, it will be impossible to have a full accountability using this technique because of the problem of the black box. Some experts propose as a solution pre-audits, but who will do it? This is my question. Which regulator or auditor has technological capability to audit such complex system? Also, audit system at start does not solve the problem because they change over time. And still another point, another question, another challenge, still, that is the protection of private property of system and algorithms that make more difficult the audit process. A global governance is necessary. I think everybody is agree about that. In all the panels around the world, they say that we need a global governance. But how to make a global agreement possible? I think we know more what you have to do, but the point is how to do that. To play a leading role in this new environment, talking about Brazil, Brazil needs investment in infrastructure, an open source platform, and it's very important, Portuguese database. The hegemony of the English language not only compromise efficiency and reliability for non-English speaking users, but tend to generate hegemony of American culture, okay, that I call it monoculture. The environment issue, a topic outside the agenda of AI regulators, is strategic in Brazil's relationship with the rest of the world. And the AI innovation path will increase the data-rich system has a significant carbon footprint. AI regulators should include obligation to reduce carbon impact, optimization of training and deployment process, and use of clean energy. This is something specific about Brazil that I hope that we include in the Marco Civil da Inteligência Artificial. The truth is that I have a lot more questions and doubts than answers. That is why I defend strongly an appropriate time for the debate on the proposal, the regulation proposal, PL 2338, so that in the end we can efficiently have a regulatory framework in Brazil that protects society, encourages the innovation, and face market concentration. We need time to have this process. I'm afraid that you don't give this time and maybe have the approval of this PL before the end of this year. I think it will be a mistake, a problem for Brazil, because we need time for the regulators to understand the object that the regulation, time to discuss with the society, time to involve in the process effectively and strongly the sectorial regulators. I think it's institution like central bank must be in the process as one of the protagonism, not only sometimes involved or send something, but be part of the process as all of other the sectorial regulation agencies. And to finish, congressmen need time to become familiar, as I said. As I had already said, with the objective to be regulated. It's crucial set minimum standards like ISO for ethical and sustainable AI. And in parallel of the process of regulation, we need to establish the standards. Because when you read all the proposals, even the AI Act, the European Commission, or our proposal that are now in the Senate, all of them, they need to have a standards, because if not, there are a subjective interpretation that will be very confused in terms of law. And then,
thank you.
As I said in the beginning, I don't have answers. I have a lot of questions and doubts, and I think ChatGPT or the other AI I forgot AI
softwares, maybe.
Oh, oh, well, it's and the new models, the AI generative, they make more complex the process, and the future, the future will be more and more complex, and that is the challenge for everybody, for all of us.
Yeah. Thank you, Dora. I know that I put you in a difficult position, and as a moderator, it's easier to me to make questions than answer them. So I'm enjoying this position just to try to understand it better. But thank you for your contribution. And I think that you brought a lot of aspects that José Renato is going to bring to us in his speech, because all the safeguards that you brought and these regulatory initiatives might be being developed in Europe, right? I think like when we talk about this development of regulation, we can't dismiss that Europe has this very important part on this. So I would like to ask José Renato how generative AI has been approached in Europe, especially because we know that there's a lot of important discussions around there. Please, José Renato, if you can help me with that one.
Hello, everyone. Good morning. This is a pleasure to be here. Thank you so much for having me. And yes, I'm going to approach a little bit of what has been discussed now. The European level with regard to the AI Act, with a focus on the text that was recently adopted by the European Parliament, and also trace some considerations of potential ways that we could move forward in Brazil and Latin America as a whole, what could be changed, what could be added. Because I think that what was brought into now in the AI Act is just one step forward of it, but I think that we have capacity to maybe to go even a bit further in this regard. And the approach that the European Parliament now is given, first of all, the way that it's conceptualizing these systems is using the terminology foundation models instead of generative AI. And they use three main parameters to describe them, which is systems that are trained upon large pools of data, that they are applicable to a wide range of tasks, and that they have a generality of output. And the way that these systems are described in the risk-based approach of the AI Act has a quite of a hybrid nature, which stands between high-risk systems and let's say the rest of AI systems that are not the ones prohibited, of course, and that are not high risk as well. And this might come ending up like blurring the line between how should the enforcement of how should the compliance of the rules applicable to foundation models take place, whether they should be identical to the way that, for instance, documentation is made or risk assessments are conducted as they are in high-risk systems or not. And also, this might end up in issues related to what would be the power of regulators to enforce these rules. And we can see in Article 28B of the AI Act many performance and documentation obligations, which trace general parameters towards like what these systems need to do, without necessarily saying which standards should be reached, which I think on the one hand is an issue, because it makes the legislation not clear enough for compliance and for society as a whole to do an oversight about whether these systems are being safe, are respecting fundamental rights or not. But at the same time, they might be seen as a first step, at least, to grasp more information about these systems. So, for instance, the rules require that providers, deployers, and users of these systems demonstrate how they have identified, reduced, and mitigate risks for health and for fundamental rights, for instance, that they use data sets that are subject to data governance measures that mitigate biases, that ensure appropriate levels of interpretability, predictability, cybersecurity, bias mitigation, and etc. That they apply means in the design and deployment of the systems that reduce resource consumption and waste, with a focus, for instance, on energy efficiency and so on, and which also requires that they have a system for logging the consumption of these resources by the systems. And further than that, notifying users of it that they are interacting with AI systems, and also obligations related to content moderation and against unlawful content that might be conveyed in the systems, and the disclosure that in case they have been trained on copyright data. And well, even though, as I mentioned, this can be an interesting first step, I think that they're not clear enough, as, for instance, not just regarding the parameters that I mentioned, but also how should the measures for complying with these rules, how should they be documented for further assessment, especially because the prerogatives that regulators will have to have access to, for instance, to the capacity to do investigations, to do inspections, and be it physically or remotely with regard to the systems, and also like to audit them. This is a bit blurred because these obligations still apply in the text of the AI Act only for high-risk systems. So one question that comes is, will the prerogative for regulators to have full access to training, validation, and tests and data sets be enough to approach to assess compliance of the systems? And will they have the power to audit them in the end? So this is, in my view, yet a bit unclear. And while much has already been touched upon issues related to data protection, I think that even though many interviews, many public relations reports that are being issued by these companies, even though it seems that they live in a world where there is no regulation applicable to them, be it consumer law or data protection, but we have, for instance, the LGPD in Brazil, we have provisions that obligate them, demand that obligate these companies to, for instance, provide access to data, provide means for data limitation for data process, and so on. So like this is already established in the LGPD, and I think that what needs to be done at this moment is to enforce these obligations. But I think that other issues might be dealt with regard, for instance, to disinformation, to environmental issues, to digital colonialism, and also to the way that compliance and enforcement should be done in our region as a whole. With regard to disinformation, I think that one possible way forward that we could do is following what a specialist in the field here in Germany has been talking about, Philipp Hake. I think that we could bring measures when regulating generative AI that are closer to platform regulations that are being developed, that were, for instance, the Digital Services Act. And now in Brazil, there are some provisions quite similar being discussed under the bill proposal on the 2630, which are, for instance, the existing providing for notice and action mechanisms and for the accreditation of trusted flaggers. With regard to environmental issues, I think that we should have more specific and explicit possibilities for regulators to have the power to determine reasonable levels of resource consumption for the systems, something which will take place with time, of course, after receiving and having access to information on how the systems are trained and bringing comparisons about and compare them. And so it is extremely important that we have obligations for these agents in the supply chain of the systems to bring forward reports, and that these reports can be subject to audits and so on about this theme. With regard to what I mentioned about digital colonialism, I think that these systems might be deepening this phenomenon, which many scholars have been discussing about, this, let's say, this further exploitation of countries, of post-colonies, of countries from the majority world, in which Brazil, of course, is included, which relates, for instance, with the exploitation of workers, which we saw with regard to ChatGPT, the hiring of workers in Kenya for very low income salaries, I mean. And I think that even though we don't need to have specific obligations or rules regarding employment relationship or minimum salary in a regulation about AI, I think that we should consider it. We should consider obligations for the provision of information about, for instance, if a company has been employing outsourcing labor force for content moderation and data cataloging, that we have information about how many workers are employed, for what purposes, under what working conditions, for what remuneration, which company was the intermediary, what are if there was any, of course, what is the demographic profile of these peoples, and so on. And I'm going to moving very quickly to finish my talk. I think we also should touch upon something that Dora mentioned, which relates to the narratives that these systems are putting forward. Very few companies are concentrating the power to convey information in a way that goes a step further to what, for instance, search engines have been doing, for instance, as they have the capacity to present while search engines could present alternatives of content in different links. Generative AI, such as ChatGPT, can bring one input at a time. That might not only disinforms society, but also reduces our capacity to a further diversity of information, which ends up following an ideology of universalism, which comes from the global north, and which ends up some sort of epistemicide of the knowledge that is produced in the global south. And to finalize, I agree with Luca that we don't have the necessary incentives to ensure compliance. And I think that we need to think of alternatives. Recently, there were some news about the FTC in the US talking about algorithmic disgorgement, something which technically can be quite complex, because many algorithms are used at the same time, but we should start discussing it, or maybe suspending non-compliant companies who have their systems in the market and so on. And that it requires not only international cooperation, but also policies. And I mean, to tackle all these issues, not only regulation and international cooperation, but also policies that makes us as a country, as a region, more sovereign with regards to what systems are interacting with our societies. And that's why I think that we should also be thinking of strengthening the debates on the Brazilian AI strategy and national strategies as a whole across our region. And well, I'll stop here. I think I went a bit further over my time. Apologies for that. And I'll be happy to participate in discussions afterwards. Thank you.
Thank you, José Renato. It was really, it was great to hear you. I think your insights about digital colonization and the way that you organized all these developments on Europe were very enriching. So thank you very much. And I think now we need to talk what's happening outside Europe. Because sometimes when we are talking about regulatory frameworks, we have this maybe Eurocentric vision of the developments. And I think especially here in CPDP Latam, and we need to look further from Europe and further, no, closer actually, to understand what's going on other countries. So I would like to ask Franco, how is the topic being addressed on South America and other countries? And do we have a model, or what lessons can Brazil learn from this experience? So thank you, Franco, again for the joint proposal of the panel.
Thank you very much. I feel very humbled to be among such great specialists. Few comments before I address the trends, the regulatory trends that we can already identify in Latin America. Regarding generative AI, there seems to be two clear narratives, two contradictory narratives among this phenomenon. The first one is that this is the best thing that has ever happened to humanity. In my perspective, this sounds a little bit naive. This technology is still developing, and there's a lot of issues with the outcomes that sometimes it produces, such as bias, which is absolutely, natural, seeing the text and data that it's mined to train such systems are constructed by human beings, and human beings have bias inherently. So there's still a long way to go to make these technologies more accurate. And the other narrative is that this will be the doom of humanity. This also seems to be a little bit exaggerated. And this second narrative comes with the endorsement of great thinkers and great entrepreneurs in our society, such as Yuval Harari and Elon Musk. I don't think they are in the room, so I can call their names without. So yeah, what you could think about that is more like a marketing strategy than anything else, or probably this is a way to gain advantage. I mean, competitive advantage from them in regards to other competitors, other developers in the market. So these two narratives, I think, there are two way too extreme, and that we do need to address this challenge of regulating AI in a more serious way, in a more interdisciplinary way. So I think that there's a philosophical question here. I'm not a philosopher myself, but I've read it in a couple of books, so I also feel comfortable of sharing it with you. And the question would be whether we want AI to look and to act the way humans act, or if we want to create AI in a way that it becomes a tool for human beings, in the way that they can produce tasks that they are hard for human beings, but in a way there's a need of recognizing that the current state of AI is narrow AI. They can only produce one specific task, and there are some ideas on how they could create or they could address different tasks in with a single prompt, but this is all very experimental at the moment. So this is just to demystify a little bit what AI is all about. I think as policy analysts, as lawyers, and as people from social sciences, we do need to understand these basic concepts in order to address this challenge in a more coherent way. Then before addressing the regulatory trends in Latin America, there's also an emerging agenda that comes before regulating AI in the region, and that is the one regarding the update of our data protection laws, and in some countries, the passing of data protection bills in order for data protection to be a reality, regulatory reality in our region. I think it is a must. And also, since AI is trained with copyrighted material most of the time, there's also a need of updating our copyright regulation in the region to be able to develop a competitive industry. Without this, all we can see is a potential mass infringement of copyright in order to create this AI industry that most countries want. And this is a little bit contradictory as well. So I do think it's two pillars, data protection and intellectual property, needs to be addressed before anything happens in the AI regulation landscape. That being said, I want to start my short analysis by saying that most countries in Latin America have published national strategies to move forward with AI. These strategies are not binding, they are not proper laws, they are just an intention of will, they're a description of will, and most of them, if you analyze them, they are focused on implementing and deploying AI in the public sector, which is, very much, it is very interesting. We do have to keep an eye on them in terms of human rights protection, since automated decision can sometimes infringe fundamental rights. There are some clear contexts where this can happen, especially migratory context, for example. But of course, there's a lot of different realities where automated decision-making can create great risks for fundamental rights. So these national strategies are also a key element for understanding how the region is moving forward with AI regulation. And also, some of these strategies also create a infrastructure for investing in the private sector that it's developing AI, which is, pretty obvious that this is needed. But the means for investing and for coming up with these resources are not very much clarified in these strategies, so there's still a doubt there. Beyond these national strategies, we can list a number of countries where there has been bills proposed in Congress or the Legislative Assembly to regulate AI. There's a clear trend in the region, and that is to follow the EU AI Act in terms of identifying different levels of risk and coming up with different requirements for developers that are behind these systems, depending on the risk that they can create in our society. So this is very much spread out among the different bills that have been presented. Just to spoil, just to share a spoiler, the first country that has passed an AI law in the region is Peru, which recently passed a law that it's called, I'm going to say it in Spanish, I'm sorry, Ley que promueve el uso de la inteligencia artificial en favor del desarrollo económico y social del país. I don't know if you all understood what I said, but from the title, you can already infer that this is a national interest purpose, and that this law is pretty much aiming to developing an AI infrastructure within the public sector in Peru. Of course, there are some investments for the private sector and so on, but overall, this is a very short law. And what it creates is pretty much a sort of list of principles, ethical principles for responsible AI, and also security principles based on these different potential risks that I already mentioned. And they do include the need to create a governance system around AI in the country, which is quite interesting. And and they do declare that there's a strong need of respecting and observing fundamental rights when deploying AI systems. But again, this is a very short law. It's not very clear how it's going to be implemented, and who is going to be in charge of this, and how it's going to unfold in the country in the upcoming years. But Peru moved forward first in the region, and it's also following this trend that I mentioned. Two other countries in the region that are moving forward as well is Argentina, with 3 different bills. One is a very, very short bill. It only includes 2 or 3 articles, and the intention is to update an already existing law to create a registry for AI systems, but it doesn't mention whether these systems to be registered needs to be high risk systems or low risk systems. I mean, it's not very clear on the scope of the registry. So I don't see a lot of future in that bill. But there's 2 other bills in Argentina. One, I think it's a little bit more on the spot, which is the Marco Legal para la Regulación del Desarrollo y Uso de la Inteligencia Artificial, that creates basic principles very much in line with the ethical principles for responsible AI that you could find in soft law, or you could find also in the EU AI Act. And the third one, it's a bill to foster AI deployment within the educational system. Of course, this law is pretty much focused on creating capacity building programs and investment for universities and schools. Kind of, the intention is here to create a landscape in the country, an ecosystem in the country where human resources can actually compete in AI development and deployment in the near future. I don't know what the future is gonna be for these 3 different bills in Argentina, but I do think that we can identify some of the trends that the EU AI Act brings to the table here as well. And it's very interesting to keep track on them. Let's see what happens in the following months. And then I'm going to speak a little bit about the Chilean bill. Chile has also presented a bill that it also has very much the same elements as the Peruvian or the Argentinian general AI regulation bill, which is defining basic concepts such as what algorithm means, artificial intelligence means, and bias means, and so on. Kind of a glossary where you can find the basic concepts around AI and that will serve anyone trying to understand what the bill is about and trying to present technical vocabulary for the general public. It also creates a qualification of AI systems based on their capacity to create risk. Again, we can see this happening in different countries. They differentiate unacceptable high risk. Those systems are banned, absolutely banned. Then they identify high risk systems. They need to be approved by an authority that will be created if the bill passes. And these high risk systems are very much the same as the one that Europe recognizes. For example, AI systems in the context of high procedures or AI systems used for managing critical infrastructure. Also, it adds a lot of goodwill declarations in the bill, such as any, for example, no AI system should create a discriminatory outcome. Any outcome should be respectful of fundamental rights, and so on. I mean, this is very much in line with everything that we can see in the region, and of course, it's a mirror of what is happening in the EU discussion. There's also a bill in Mexico, which is very much, I would say, the analysis, a basic analysis will throw that this is very much the same as the Argentinian or the Chilean cases. So I'm not going to stop on the Mexican bill right now. We can discuss that later if you want. You can find me outside the room and we can have a talk about that. But I want to stop on the situation in Costa Rica. I think this is going to be amusing for most of you, but Costa Rican legislators thought, what's the best way of regulating AI? Well, they come up with a solution which is rather creative. They said, okay, let's ask ChatGPT to draft a bill. So that's what they did, actually. They entered the following prompt. I translated with Google Translator just to be in line with automatic, processes. So they introduced the following prompt to ChatGPT. They said, think like a lawyer and legislative advisor. Use technical vocabulary and generate a bill to regulate artificial intelligence, taking into account the political constitution of 1949 of Costa Rica. Ask anything where you have doubt. This is amazing. I mean, in my perspective, asking ChatGPT to replace the work of legislators by legislators is pretty much ironical. It's pretty ironic, right? It seems like these legislators want to, be left without a job, or I don't know. Maybe they are creating the perfect storm for them. But ChatGPT did create a draft, and I can share it with any of you if you want to take a look. It's in Spanish, of course. And the bill is a complete mess. If you go over the different chapters, how the bill is structured and so on, you could easily feel uncomfortable or intrigued by how ChatGPT drafted the bill. Of course, it defines basic concepts such as the other bills. It also creates a registry, although it doesn't say this registry is for unacceptable risk AI systems or high risk systems, but it does create a registry, which is very much in line with what I was talking about before. And it also creates a mandatory assessment of the risk around certain AI system, which is, very, very logical. And it's also it also says that regarding automated decision making, there is an obligation from AI developers to provide explanation and transparency. And there's a whole chapter dedicated to data protection and to the respect of human rights. So, I mean, there are a lot of common elements within the bill, but the structure of it is a little bit confusing, and it's rather short as well. So you cannot analyze much of this bill because there's no much to read from it. But again, what I find amusing is that legislators reach out to ChatGPT to draft a bill to regulate AI. I think this illustrates how legislators in our region wants to be in trend, wants to be in the front line of the technological innovative landscape, and how sometimes they are very much confused on what their job is. This is, of course, my opinion, but I think it's the only case in the world where ChatGPT is working closely with legislative assembly. So I found it quite interesting, and I wanted to share it with you because I think many of you will have a lot of fun going over this bill and reflecting on why legislators want to go to ChatGPT and ask ChatGPT to do the job that they are being paid and elected to do. This is very, very interesting. Finally, this bill is signed by two human legislators. So they are somehow asking for all credits on the authorship of the bill. I mean, of course, they have to sign the bill for it to be introduced in the Legislative Assembly. But again, doesn't it seem to you like a little bit funny that they first start the bill saying, we went to ChatGPT because we're very innovative and we asked ChatGPT to draft this bill, and that's how cool we are. And then at the end of the bill, they're saying, okay, this is our work, this is our authorship. So I think this is like a reflect on the current state of AI regulation in Latin America. And again, just to close this first intervention, I do think that the region is moving fast in terms of AI regulation. First, many countries publish their national strategies. They are some of them are very long and very and full of desires and wishes. If you go over the Argentinian national strategies, 180 pages of wonderful prospects for AI in the country, and it doesn't identify where the money is going to come from, who is going to be the developers, who is going to be responsible for deploying such systems, and who is going to be responsible when things go wrong. So I do think there's a little bit of a hype around AI within our regulatory bodies in the region so far. Last but not least, I do think it's a good thing that our countries are trying to address this challenge. But again, I want to enforce what I said first. I think we do need to go over our data protection laws and our copyright laws before we try to regulate such a complex challenge as AI. Thank you.
Thank you, Franco. I really want to have access to this last bill. I think it's very interesting. And well, in this context, I think that our final speech here with Paula, I think she can bring to us how does Brazil how can the AI regulatory framework in Brazil be analyzed in this context? Is this sufficient, or does it address the AI generative AI concerns that we raise in this panel? And is LGPD enough, or can LGPD address these concerns? So Paula, please feel free, the floor is yours.
Hello, thank you. Can you hear me? Yeah, okay. So they are not simple questions, but I would like to begin my speech saying that the topic of AI regulation is not new. So I think it's good with ChatGPT that this discussion came to the popular speeches and conversations. I don't think this introduction to the public are a positive way, because I'm hearing a lot about existential risks and how AI may contribute to the human extinction. But I think we have already some real problems and real risks that we should think about. And as my colleagues already said, we have problems related to disinformation, discrimination, competition, and also environment sustainability, copyright. So a lot of different risks that are already in the real world. So thinking about Brazil, I think we have already legislation that could address some topics of AI. So we cannot just ignore that we have a consumer defense code, that we have competitional law, and of course we have general data protection law, our LGPD. So as Lucas said, we have some rights in our legislation of data protection, but I think we already have some problems related to the enforcement, especially because of the way ChatGPT is processing our personal data. I also tried to introduce a question there, like, who is Paula Guedes, as Luca did, but the answer that I received was, we do not process personal data. We don't know who Paula Guedes is. So I think I'm not so famous as Luca. But we have some topics in LGPD that should be enforced, like the legal basis, the rights of data subjects, and the principles, of course. But I know that in practice, when we are dealing with ChatGPT, we have a lot of doubts on how it will be in the future. So I think NPD will have a lot of things to think about in the future. But the future, no, well, actually today. But I would like to focus my speech in the Brazilian regulatory scenario of AI regulation. So even before we launched ChatGPT, we have already a lot of discussions in Brazil related to this topic. In the executive context, we have in 2021 the Brazilian AI strategy, published, but we know that this strategy was really criticized by different sectors of the society because it was really generic and also lacking effective planning related to how AI will be applicable in Brazil. So I think this first step is to think about how this Brazilian strategy could be updated to think about the concrete risks brought by AI and specifically by ChatGPT. But thinking about the legislative process in Brazil, since 2020, we have some bills also dealing with this AI regulation. I could spend hours thinking about this process because we have a lot of things that happens in the last years, but I would like to reinforce that today the most advanced AI regulation project in Brazil is the Bill 2338 that was recently filed by the Senator Rodrigo Pacheco in the Federal Senate. So this project was the result of more than 6 months of work of a commission of jurists. And this document was also introduced in the Congress right before the boom of generative AIs in November of last year. So despite not having a specific topic related to these generative AIs, we have in Article 13, paragraph 1 in this bill, a mention of general proposal AI. Although we do not have a conceptual of this in the bill, we have this mention there. So in this topic of in this field of the legislation, we in Brazil already was thinking about this problem. So we understand today that the bill remains applicable to these systems, but of course we need some updating. Since the main problem related to this bill is that we adopted a risk-based and rights-based approach, and this is really challenging for AI, generative AI, because this model is really contextual. So we think about AI in specific context of application, and then thinking about this context, we see the risks and how to mitigate these risks. So these generative AIs can have different purpose. We do not control how they will be applicable in the future by the users. So it has a problem related to how to deal with legislation that are so contextual with this uses that can be brought, and we don't know how they will be applicable. So despite not solving the challenge itself, I think the Brazilian bill with this prediction of general purpose artificial intelligence winning a risk-based approach, establishing specific rules for these models is the first step in this regulation. So also in Europe, we see a similar topic related to this after the Parliament, the European Parliament, dealing with this question. So we do not know how it will be applicable within this idea of risk, but we must consider not risks that already exist, but also foreseeable risks, like risks that can be expected based on the precautionary principle. So even though it's not, even though we don't know how this AI will be applicable in the context, we have to at least predict some certain risks that already exist, and this uncertainty and lack of knowledge cannot be used as an excuse for not employing measures related to the regulation. So in Brazil, we think about risks, but also risks that could be foreseeable. So not certain risks, but also foreseeable risks. So this is another way that this bill try to think about how to deal with this ChatGPT problem. So if the bill 2338 established that if general purpose AI is used for one of the purpose listed in high-risk situations, these systems must comply with the set of governance obligations, and then including impact assessments. And within these impact assessments, just general purpose AI agents must consider and record, among the other elements, as the bill says, known and foreseeable risk associated with artificial intelligence systems at the time as it was developed, as well as risks that can reasonably be expected from it. So we consider these two kinds of risks. However, certain risks cannot be guaranteed that will exist in the future. We have already risks that exist. So as I was saying, disinformation, discrimination, and also copyright and so on. So this by itself would already justify that these systems undergo risk assessments and mitigation. But I know that this is a critical approach because we don't know all the risks that can happen in the future. So I think we have this complex situation in the bill right now. We have a good project, but we can develop it. Like when we are thinking about Europe, for example, after the parliament changes recently, they propose more agents in the value chain of AI. So we have to consider these things also in Brazil, because I think in the bill right now we have already just provider and operator, but this value chain can be more complex. So we have to consider how to include other agents that can have a role in this topic of ChatGPT. And as was mentioned by José Loreto, we have to return our discussion for Brazil, thinking about these models are training in the global south and they are applicable everywhere. So for example, the ChatGPT and Dolly, Bard, Midjourney are all US based. So the knowledge, the culture, the specific particularities when creating these systems are based in the north, in the north of the world. So it will probably be more problematic when we are thinking about the majority of the world, in which Brazil is included. So it will reinforce structural oppressions, colonialism, and other discriminations of vulnerable groups. So I think the future view of AI in Brazil will have to consider this topic and to think about specific ways in which the legislation could address our problems in our context. So I think we have a good proposal, a bill right now in the Congress. I think we will have to have more discussions with civil society and also experts, like technical experts, because we have to have these multidisciplinary conversations to have a good legislation. But right now we can see some developers that can be achieved in the legislation. So the refinement of the definition of the agents prescribed by the law, because we have already just 2 and we could have more. And another thing that we have to think about how to enforce the future law. So the bill already mentioned an AI authority, but we don't know who this authority will be. So if it will be a new one of already existing one. We heard NPD president yesterday mention that they know they want NPD to be this authority, but we don't know how it will be in the future. But even though we don't know how this legislation will be enforced, like who will be the authority, we have to consider that we have a complex system of enforcement of other agents in Brazil. So we are not, we have already other authorities that can deal with this future AI authority. But we also have to think and include civil society in the discussions, because we can also be, we can also do this supervising of this AI regulation. And to conclude my speech, I think we have to have, if the decision will be to have AI impact assessment, to publish the conclusions of it, because with this publishing, we have the society as access to these documents, and we can see how these systems are being enforced and governed. So I think I could not respond to all the questions that you posed related to the risks, but I think we have already a good first step, and we will discuss later. Thank you.
Thank you, Paula. And well, I think we don't have time for questions, but I would like to thank all the panelists for this brilliant exposition, because our idea was to try to take out of the noise around this discussion, but I think we could do more than that, and I really appreciate it. So I would like to thank everybody, to thank all the audience, and as we don't have time, I will wrap up here and see you on the next panel. Thank you very much.